paper is a kind of an update or revisiting of earlier work that I did in light of developments in the case law, new empirical literature on labor markets. So in earlier work, including a book published in 2021, I argued that from the standpoint of antitrust theory and antitrust law, we should observe and I suppose celebrate antitrust cases against employers brought by workers. And there is no particular reason, I argue, that antitrust law should be confined to output markets or, input markets that involve, companies rather than workers. And then the puzzle which I've been, thinking about for a long time and talked about in this earlier work, is that there is this big difference between the number and importance of output cases, or what I'll just call product market cases, and labor market cases. And of course, this has been true for basically the whole history of antitrust law. There isn't a particular legal reason why there should be a difference. The Supreme Court acknowledged as far back as the 1920s that antitrust law applies to labor markets. Antitrust law applies to all kinds of markets and not just to product markets. Now, in the last few years, there have been a kind of small wave of litigation in the area of what I'll call labor antitrust. So there have been cases, there have been enforcement actions by the government. And of course, it goes back to before 2021. It goes back to the teens. So that's an interesting development. And the question is why the litigation gap is beginning to close and what we should think about these developments. And this paper is a bit of a hodgepodge. It talks about lots of different issues related to these developments. For the purpose of this talk, I'm going to focus on two themes in the paper. The first theme goes back to this question of theory. The question I want to ask is again, is there any reason to think that product market antitrust is more important than labor antitrust, that there should be more product market cases, for example, that more theoretical and enforcement resources are devoted to product market cases than labor market cases? Now, I'm not just going to repeat my earlier argument that there is no reason to think there should be a difference. I also want to argue that, in fact, we should observe more labor market cases. That labor market cases are more important than product market cases. And then the second theme of my talk today relates to the case law, the developments in case law. I want to argue that, there's not a simple story here. Some of the cases are good, some of them are bad, some of them are a mix of good and bad. But it's interesting to see how the courts have addressed these increasing labor antitrust cases. So first thing on theory. So when I say theory, I mean something like conventional antitrust theory as it is today, which means antitrust law that's been heavily influenced by economic thinking going back a few decades. One point I want to make, which might be obvious but isn't discussed much, is there's no reason in economics, in the methodology of economics, for thinking that consumers are somehow more important than workers, or that there's really any difference, any relevant difference between labor markets and product markets. One way to think about this is to recognize that the difference between a buyer and a seller is not something fundamental to economics. It is a kind of consequence of the introduction of money into an economy. Okay, so in a pure barter economy, in the mythical barter economy, there's no such thing as a buyer or a seller. People just trade things. So I trade my donkey to you, and in return, you give me some bales of hay. Neither of us is a buyer, neither of us is a seller. And yet you could have in such an economy problems of problems of market power. We wouldn't call it labor market power or product market power. We would just call it market power. For example, if one person owns all the donkeys and other people have to trade a lot of their goods in order to obtain a donkey from that person. So when you introduce money, then we start talking about buyers and sellers. Typically, a buyer is someone who gives money for a good or service, and the seller is somebody who gives a good or service in return for money. This creates a kind of an illusion that there's a systematic economic difference between these positions, but there really isn't. And then, you know, bringing down the level of abstraction a little bit, economists tend to celebrate competitive markets. Antitrust law reflects this view. We want all markets to be competitive. We don't want just product markets to be competitive. And it's just, you know, basic economic theory. Now, I've been making this argument for a while, and I've confronted counter arguments. One argument is that consumer harm is easier to identify than worker harm. And it's just much more convenient to have this kind of simple consumer welfare standard to guide courts and enforcement agencies. Now, this is in fact not necessarily true, although one person who's made this argument is Herb Hoffenkamp, who of course is very influential. He argues, he says, look, if we just had, I mean, he supports labor antitrust, just to be clear, but he also argues that if antitrust law just went around helping consumers, it would at the same time help workers. Why? Because if you create better, more competitive output markets, that will increase consumer purchases, which will increase demand for workers, which will, you know, raise compensation for workers and draw people into the labor market. But it really goes both ways. You know, workers benefit from vibrant product markets, but consumers benefit from vibrant labor markets. And more to the point, we know from recent cases that it is actually a lot easier in some settings to identify worker harm than consumer harm. So if you think of the no-poach cases, of which there have been many in recent years, this is a situation where two employers or two or more employers agree not to hire away each other's workers. Now, in the Dayland versus McDonald's case, a court actually said, the district court actually said, well, that could be good for consumers because labor costs go down, and that should mean that prices go down. But that's, you know, imposing an unfair burden on labor antitrust, because we don't make the same argument about anti-competitive behavior that benefits workers and harms consumers. Antitrust law has a norm where we don't justify anti-competitive behavior through cross-market benefits. That reflects a kind of administrability concern. And in the case of no poach agreements, which are certainly anti-competitive, the easiest way to think about the harm is the harm to workers, because they're unable to switch jobs, which will result in lower compensation. Now, there's another argument that's been floating around about Nash bargaining models. In Nash bargaining models, it's possible that anti-competitive behavior on one side of the market can benefit people on the other side of the market. I want to, though, reiterate that that works in both directions. Anti-competitive behavior on the labor side of the market can benefit consumers in the Nash bargaining setting, but also anti-competitive behavior on the consumer side of the market can benefit workers. This has always been a concern in the context of collective bargaining, the concern that unions would collude with firms in order to extract rents from consumers, with some of those rents going to workers, right? Now, my own view about these Nash bargaining models, I'm not sure they actually reflect the real world so much anymore. With the decline of unions, workers tend to be, are unable to um, engage in concerted action the way they used to be. So the Nash bargaining model doesn't fit as well. But in any event, even when we come up with those situations and we're pretty confident that there's a benefit on one side of market and a harm on the other side of the market, there's just no reason to think that the harm on the consumer side is worse than harm on the worker side. And the reason here is very simple, which is that people are both workers and consumers at the same time. And some recent work in economics has made a very simple move, which nonetheless clarifies this confusion about people being workers versus consumers. So these are general equilibrium models where the kind of unit of analysis is the household. And what these papers recognize is that if you're a household and there's anti-competitive behavior going on, you could be benefited on one side of the market and harmed on the other. So if you might, as a worker, be paid less, but you might, as a consumer, get lower prices. And from that standpoint, basically what everybody is doing is paying a kind of a net price at any given time for a basket of goods and services. And we don't need to distinguish people as workers and consumers to understand that anti-competitive harm will generally be widespread if employers collude and engage in other types of anti-competitive behavior. All right. Let me turn to the case law. So there have been some, quite interesting cases and a lot of, less interesting cases. The two cases that need to be mentioned initially is first the Alston case that the Supreme Court decided a few years back. Alston, like a lot of these cases, has had both good and bad effects. So the good effect is really, I think, comes out of Justice Kavanaugh's concurrence, in which he says, very clearly and eloquently that if schools under the umbrella of the NCAA agree not to pay their workers, which are student athletes, that is anti-competitive. That's just price fixing or wage fixing, if you want, and is plainly illegal. And the various efforts over the last several decades to justify this behavior, mainly by looking at consumer benefits, this idea that fans enjoy football more if they know that the players are actually not being paid. That's irrelevant legally, and it's actually empirically nonsensical, or at least wrong. So that was very helpful. And I think the Alston case has helped very much in the NCAA cases over the last couple of years. But more broadly, it's enabled courts to see that certain sort of rationales that would never be accepted on the consumer side of the antitrust litigation are equally fallacious when we're talking about workers. Now, another important case is the Deland case, the Seventh Circuit case. The opinion was written by Judge Easterbrook. And this, too, had some good and bad elements. The good element was Easterbrook saying very clearly that under Alston, harm to workers matters, is a relevant concern in antitrust law, and that you cannot do cross-market balancing. So the fact that burger prices might go down if McDonald's colludes not to hire away workers is irrelevant. Okay. On the less good side, though, I think Deland's reflects an intellectual prejudice that we inherit from, a number of decades of the assumption that labor markets are competitive, and that is that it's implausible for low-skilled workers like fast food restaurant employees to be a market, to not to have substitutes for their occupation. Of course, a McDonald's worker can probably leave McDonald's and go work for Burger King or another fast food joint. But this type of movement among firms is much more difficult than people assume. People develop relationships with their colleagues. The geographic market can be very unintuitive because it might follow, for example, subway lines and bus lines, and even in what might seem to us as very simple employment settings, there are a lot of frictions that make it difficult from employees to leave and find a substitute position somewhere else. Okay. There are other cases that are similarly troubling, although also grounds for optimism. There have been a few cases, including criminal cases, in which employers are accused of engaging in like very basic, simple, horizontal collusion, often no poach agreements or wage fixing agreements. But there are some courts, not a lot, but there's some courts that simply don't accept that that could be illegal and require plaintiffs or the prosecutor to prove that not only did the employers enter into an agreement, but that they also caused harm. That is, that the agreement is meaningful in some sense. That's a word that's used in these cases. That's not a requirement on the product market side for lots of familiar reasons. There's no particular reason why it should be a requirement for the labor market side. And at least in one case, I think this sort of thinking caused a court to, take the case away from the jury and rule in favor of the defendants. Another example is the ancillary restraint doctrine. There have been a bunch of cases where courts have applied the ancillary restraint doctrine more generously to employers than they do to sellers, allowing employers to avoid the per se rule by coming up with, justifications for why they're working together. And then one thing that I think needs to be pointed out is that there just aren't a lot of cases still. And I think that continues to be a puzzle. And I'll give two examples of this, two, I guess, negative examples. The first is that in the product market side, we often see Section 2 cases or even Section 1 cases where the anti-competitive behavior is exclusive dealing or something like that, right? Now, if we take that idea and transfer it to the labor market, the analogy would be something like a covenant not to compete. Now, recent literature shows that covenants not to compete are extremely common in the United States, and for that matter, in other countries. Tens of millions of workers are subject to covenants not to compete. There's anecdotal evidence suggesting that firms use them broadly, applying them to their entire workforce in a way that would make it difficult for a competing employer, or for that matter, a competing seller, to enter a market. And yet we see no such cases, or very few cases. There are few sort of cases where allegations like this are made, but are weak cases. And the second example, which I also think is interesting, is the absence of cases, or very many cases, about involving intermediaries. So we know in the product market side, there are lots of cases involving intermediaries. Think of cases like, BMI or Chicago Board of Trade. And intermediaries are often in a difficult position because, sometimes there are economic justifications for imposing restraints, although the restraints might also cause anti-competitive harm. So they're common on the product market, but very rare in the labor market. There are a few cases involving staffing agencies, and I suspect that in the future we'll see a lot more. There are many staffing agencies which are absolutely enormous national or even global conglomerates, and it seems likely that they may use anti-competitive non-competes or no poaching agreements to protect their business and suppress wages. There has been one important case, I think, that many people are probably not aware of. It's called Lee versus Zuffa. It's a Section 2 case against promoters of mixed martial arts that it settled recently. I think it's at least partly settled, and I think completely settled. for over $300 million. And I believe this is the first Section 2 labor antitrust case. Took 10 years, but maybe it means that there'll be more such cases in the future. Okay, so the judicial response to labor antitrust cases has been mixed, a combination of skepticism and receptiveness. And so the question about is, and I say relative to product market cases. And the question is whether this lingering skepticism can be given a satisfactory explanation. Maybe it's justified, or maybe it's not justified. But if it's not justified, the question is why we see it among the courts. All that I'm going to say that is in the last few years on the empirical research, the empirical labor market research has continued to confirm and strengthen the premise of labor antitrust by showing that labor markets are indeed highly concentrated and that there's a great deal of wage suppression, that wages are, for whatever reason, below what the competitive rate would be. Okay, so that's all I have to say. I think there's been a lot of progress. You could say the glass is half full, or maybe the glass is half empty, or maybe the glass is both half full and half empty. But that's all I have to say, and I look forward to hearing comments or taking questions.
Okay. Good morning, everyone. Good morning, Professor Posner. Thank you for that thought-provoking presentation of your article. It is definitely a timely and important contribution to the ongoing debate about the role of antitrust law in addressing labor market issues. It also, of course, builds on other significant work you have done in the area, including your book, How Antitrust Failed Workers. The title of your article in the Antitrust Law Journal is The New Labor Antitrust. And as you explained, this is because there's a shift in focus from antitrust liability of unions to the liability of employers, who are now seen as the buyer-side monopsonists or cartelizers of labor markets. Workers are now the plaintiffs and the employers are the defendants. But as you note, courts and many commentators remain skeptical about new labor antitrust. Now, I first presented on this topic at the IBA meeting in Mexico City last year. It was a multinational panel consisting of academics and practitioners from the Americas and Europe. And I can confidently report that there was a sufficient degree of skepticism and uneasiness about the new labor antitrust. It was especially interesting how the debate essentially turned into a discussion of the consumer welfare standard, and how there seemed to be a general unease about extending criminal penalties in particular to labor market violations. Now, based on that experience, I was very happy to read in the introduction to your paper that you plan to trace out the various sources of uneasiness that lie behind the skepticism towards new labor antitrust and consider them carefully. And you have certainly done that and progressed the field considerably. It is also very timely in light of recent enforcement efforts. In her first antitrust address last week, Assistant Attorney General Gail Slater said, and I quote, "We will also stand up for workers when dominant firms impose restraints of trade, whether directly on workers or on the businesses who employ workers for them. Because the antitrust laws protect labor market competition, any conduct that harms competition for workers can violate not only the spirit, but the letter of the antitrust laws." Now, the Antitrust Division has also launched the Anti-Competitive Regulations Task Force, and Ms. Slater specifically noted that the task force will seek to identify and eliminate laws and regulations that undermine the operation of the free market and harm workers, along with consumers and businesses. But as Professor Posner has pointed out, this view certainly was not always the case. For a long time, competition law predominantly focused on protecting consumers from harm caused by anti-competitive conduct in product markets alone. So what are those main sources of uneasiness that Professor Posner identified? As I experienced on my panel, one of the primary reasons identified is that the current consumer welfare standard, particularly in the way it has been historically interpreted, may be considered as ill-suited for analyzing labor markets. Now, this view holds that the standard primarily focuses on the welfare of customers, requiring a showing that conduct leads to reduced output or increased prices for consumers. Under this perspective, harm solely to workers without demonstrable spillover harm to consumers in the relevant market is not sufficient grounds for an antitrust violation. Professor Posner contends that antitrust liability does not legally require consumer harm. Antitrust law applies to all markets equally, including input markets like labor markets, and there is no theoretical or normative basis for distinguishing between harm to consumers in output markets and harm to workers in input markets. Instead, Professor Posner views the historical focus on consumer harm as a result of judicial and enforcement failures and an anti-labor bias, rather than a correct interpretation of the law's goals. Now, there is obviously a clear debate about the interpretation and goals of the consumer welfare standard. And as I just said, Professor Posner asserts that antitrust law shouldn't require consumer harm and applies equally to inputs. There is indeed a legal basis for applying antitrust to input markets, including labor markets, and that the focus isn't solely on downstream consumers. The Supreme Court in the Mandeville Island Farms case from 1948, for example, explicitly confirmed that the Sherman Act protects all who are made victims of the forbidden practices by whomever they may be perpetuated. But the debate over the appropriate welfare standard, whether it should be consumer welfare or a broader standard including workers, is very much alive. Now, some commentators argue that the consumer welfare standard is flexible enough to encompass harms in input markets, including labor. But others, such as Steinbaum and Stuckey, suggest it may be ill-suited and propose abandoning it in the favor of an effective competition standard that explicitly protects upstream suppliers and workers. And this, of course, will be discussed in greater detail by Greg Worden this afternoon. Now, Professor Posner's argument aligns with the view that the consumer welfare standard is not the sole measure in antitrust and that harm to workers should be given equal weight to consumer harm. Now, Professor Posner also contends that monopsony power in labor markets is unlikely to yield pro-competitive effects, unlike buyer power in product markets, which might sometimes benefit consumers, and that antitrust liability should not require proof of harm to downstream consumers. Carl Shapiro also notes that the notion that US law is solely focused on downstream consumers is incorrect, citing cases that considered effects on innovation and suppliers and emphasizes the need to apply the competition standard to input markets as well as output markets. However, as evidenced by the ongoing debate among commentators and the judicial inconsistency, this area remains highly contested. Beyond the more philosophical debate on the welfare standard, a significant source of uneasiness stems from practical complexities in applying antitrust principles to the labor markets. I will concentrate on three of the main concerns. First, there is the challenge of empirical evidence. Jeffrey Mann and Brian Elbrecht, for instance, described the direct evidence linking mergers to negative labor outcomes as limited to a few studies, representing a thin empirical base for widespread economy-wide policy changes. They argue that the findings from studies such as those on hospital mergers are nuanced and may only apply when concentration increases significantly and workers possess industry-specific skills. They question the generalizability of these findings across diverse labor markets like grocery or manufacturing. Mann and Albrecht note that Dave Arnold's work suggests that insufficient antitrust scrutiny was not a major contributor to stagnant wage growth, which they state contradicts assertions by commentators, including perhaps Professor Posner himself, that the evidence demands aggressive reform. Now, this perspective suggests that while the potential for labor antitrust issues exists, the extent to which they are the primary root cause of widespread wage stagnation remains a point of significant debate and uncertainty. Nonetheless, it is definitely true that recent empirical work has challenged the traditional view of competitive labor markets that have revealed significant frictions, high concentration, and frequent collusion. And the economic literature in this area, as Professor Posner did say earlier, continues to develop rapidly. Now, secondly, there are difficulties in defining antitrust-relevant labor markets. Now, while the distinctiveness of the labor market due to frictions like search costs is acknowledged and even noted in the 2023 merger guidelines, this characteristic simultaneously makes market definition particularly challenging. Iona Marinescu and Professor Posner have proposed using occupational classifications and commuting zones to create presumptions for easier market definition. But other commentators observe that this approach, while potentially useful for agencies making quick decisions, risks introducing errors. Alternative methods like using worker search data or employer surveys are considered, but these are seen as highlighting the complexity rather than simplifying the task. Commentators are generally critical of claims that market definition in this area is a settled science, noting that these issues are far more acute in monopsony cases due to less precedent. Thirdly, and significantly, the application of legal standards to labor market conduct has proven challenging in practice, contributing further to the uneasiness. This uneasiness is especially reflected in how courts have approached specific practices like no-poach agreements or wage fixing. There is no doubt that courts are hesitant in applying per se rules to these cases, either by effectively applying the rule of reason or accepting relatively weak justifications for the conduct. Professor Posner acknowledges that part of this hesitancy may be the fact that conviction may lead to criminal convictions. He says that is simply how antitrust works with respect to hardcore restrictions. And again, Professor Posner is right. But I think this warrants considering further. From a policy perspective, judges seem to be reluctant to apply criminal penalties in these circumstances and are essentially finding ways around levying such harsh penalties. At least in this area, I would very much value Professor Posner's additional examination of this judicial uneasiness surrounding the impact of criminal penalties. But perhaps it is simply a matter of courts and judges getting more used to the idea of criminal penalties in this area. On April 14th in United States versus Lopez, a federal jury convicted an executive for conspiring to fix the wages for home health care nurses in Las Vegas. This was the DOJ's first successful criminal prosecution in a labor market case and could be reflective of a new trend. In conclusion, there is a significant shift towards applying antitrust principles to labor markets and addressing employer market power. A shift strongly advocated, of course, by Professor Posner. There is a theoretical basis for this application, and specific practices like no-poach agreements are generally recognized as harmful. However, the practical application faces challenges, including complexities in market definition and ongoing judicial inconsistency. Furthermore, there is ongoing debate regarding the breadth of the problem and the sufficiency of the current empirical evidence to support sweeping policy changes. The conversation around labor antitrust will continue to evolve as we continue to seek to balance the need to protect workers from anti-competitive harm with the challenges of implementing effective enforcement. I, for one, very much look forward to Professor Posner's further thoughts and work on this important topic. Thank you very much, Professor.
Thank you very much for those very helpful comments. I know we're almost out of time, so let me reply very briefly. I do think one kind of useful way to think about these issues is to compare how we think about the evidence for product market enforcement and how we do it for labor market enforcement. So of course, there's long-running skepticism about antitrust law in general. Some people, of course, think it should be abolished, but there's, I think, a more mainstream view that it should be applied in all markets in a narrow way. This is, of course, the Chicago school, and which has had a lot of influence on courts and also on scholars, I think mainstream antitrust scholars even today. So the thing is that, given the difficulties of evaluating empirical evidence, it's not difficult to make an argument that there isn't sufficient evidence for a very vigorous antitrust law. I think that the reason people's views have been changing over the last few years is a lot of sort of macroeconomic evidence about stagnating economic growth, also evidence about increasing concentration. But for example, if you look at merger retrospective studies, while they tend to show that merger law was under-enforced, all those studies, because of the usual reasons, are vulnerable to criticism. So in trying to defend labor antitrust, I try to argue that if you think that my strategy has always been, if you think that we should have antitrust law in product markets, or that we should have like a reasonable amount of enforcement of antitrust law in product markets, you shouldn't distinguish labor markets. And so when we look at empirical evidence, of course, there's mixed empirical evidence about product markets. There's, I think, the empirical evidence about labor markets. We need to acknowledge that certainly, I believe people were very surprised by the concentration levels in labor markets, which are probably, although it's hard to compare, worse than concentration levels in product markets. So I do think now then a response to that is that we don't really care about concentration, and many economists think that. But I think we've got to take, in order to get this debate off the ground, we have to take antitrust law roughly as it is. And so I want to argue that my argument is that labor antitrust should be as robust, or possibly more robust, than product market. Difficulties in defining markets, I think to some extent that's a red herring. For empirical work by economists who are trying to understand the relationship, for example, between concentration and wages, it's obviously very important to have some kind of standard, replicable way to define markets. But in actual cases, the market will be proven in a much more fine-grained way. Economists will use survey data, they'll use data about commuting, and while using a commuting zone, for example, is like might be a reasonable first cut, in actual litigation, it's possible to be more sophisticated about how market definition proceeds. The question about criminal enforcement, I think that basically what happened is that the Justice Department starts prosecuting defendants in labor antitrust cases in the late teens. Before that, they'd never done it, never in all of history. Criminal prosecution in the United States is difficult. You have to prove guilt beyond a reasonable doubt. There are all kinds of procedural protections that are not available for civil cases. And I think the Justice Department basically needed time to figure out how to bring these cases and how to distinguish cases that might impress judges and juries and cases that don't. So we finally do have a conviction in the Lopez case. I don't know whether the Justice Department will keep bringing cases like this. I suspect they will in egregious circumstances. But like in product market antitrust, I don't expect criminal enforcement to be a big part of enforcement. And then I want to conclude with a point, another point about work versus consumption. So I think, people think about work because of the influence of economics on antitrust. People think of work in a very abstract way. When someone works, they're producing a service for someone else and in return getting compensation. And I think there's this kind of prejudice, both in economics and more generally, that work is just bad. Everybody hates work. And the reason they do it is that they get money, and then they can use that money to buy stuff. And then the stuff that they buy, that's what makes them happy. But that's not actually how things work in the real world. In the real world, people derive an enormous amount of self-esteem, sense of respect and meaning from their work. Not all people, of course, but lots of people do. Work is a source of sociability. It's where people make friends. Work gives people a sense that they're contributing to society. These kind of softer, more philosophical reasons for thinking that work is important to people, I think is an additional reason why antitrust law should be enforced in labor markets more vigorously than it has in the past. And thank you very much for your attention. I really appreciate it.